Doctrine of Non-Interference or Doctrine of Judicial Stability. The doctrine of judicial stability or non-interference in the regular orders or judgments of a co-equal court is an elementary principle in the administration of justice. No court can interfere by injunction with the judgments or orders of another court of concurrent jurisdiction, even if they have the power to grant the relief sought by the injunction. What is the rationale of this rule? A contrary rule would obviously lead to confusion and seriously hamper the administration of justice. A court that acquires jurisdiction over the case and renders judgment therein has jurisdiction over its judgment, to the exclusion of all other coordinate courts, for its execution and over all its incidents, and to control, in furtherance of justice, the conduct of ministerial officers acting in connection with this judgment. What is the penalty for violation of the doctrine of non-interference or the doctrine of judicial stability? Jurisprudence shows that a violation of this rule warrants the imposition of administrative sanctions. Pursuant to the policy of judicial stability, the doctrine of non-interference between concurrent and coordinate courts should be regarded as highly important in the administration of justice, whereby the judgment of a court of competent jurisdiction may not be opened, vacated, or modified by any court of concurrent jurisdiction. So as you can see here, the judgment of the MTC cannot be opened, vacated, or modified by another MTC based on the doctrine of non-interference, because these courts are courts of concurrent jurisdiction. Another example, the RTC cannot annul the judgment of the Department of Agrarian Reform Adjudication Board, or the DARAB, which is a quasi-judicial body. Why? Because the 1997 Rules of Procedure, as amended, expressly provides for an appeal from the DARAB decisions to the Court of Appeals. The rule is that where legislation provides for an appeal from decisions of certain administrative bodies to the Court of Appeals, it means that such bodies are co-equal with a regional trial court in terms of rank and stature, and logically beyond the control of the regional trial court. Given that DARAB decisions are appealable to the Court of Appeals, the inevitable conclusion is that the DARAB is a co-equal body with the RTC and its decision is beyond the RTC's control. Here are some examples. In one case, the Supreme Court held that this doctrine served as an insurmountable barrier to the competencia of the RTC Cebu City to entertain a motion, much less issue an order relative to a share which is under the custodia legis of the RTC Makati City by virtue of a prior writ of attachment. In another case, the Supreme Court held that the issuance of a TRO directing the sheriff to cease and desist from enforcing a writ of demolition issued by another RTC over the property was held invalid for violating the doctrine of non-interference. And finally, in another court, the Supreme Court held that the RTC of Iligan City issued a writ of execution, but the judgment debtor, instead of complying with said writ, filed a separate petition for prohibition and mandamus with application for issuance of temporary restraining order and/or preliminary injunction with the RTC of Marawi City. The Supreme Court struck down such action of the Marawi City. Why? For violation of the doctrine of non-interference.